It won't surprise the government to know that the Labour opposition will be opposing this bill and will be committing as part of this legislation to repeal those most offensive parts of it at the earliest possible opportunity. Mr Speaker, this bill is an attack on the rights and wages of wage and salary earners. It is part of an attempt by this government to run down the wages and conditions of those people who work for a living in New Zealand. It is very uneven and it places the vulnerable workers, the vulnerable wage and salary earners makes them more and more vulnerable. Mr Speaker, I'll tell that member just to have a look at any wage and salary figures in a time of high employment. When low-income people get jobs, actually averages don't go up as quickly. Average wages tend to go up. Average wages tend to go up in a time of high unemployment because low-income workers lose their jobs. And if they're too thick to understand that, there's no hope for them at all. Mr Speaker, these amendments are... It's a compliment. The member says it's a compliment to call them thick, and I agree with him. I agree with him. It's not fair on thick people to put Paul Quinn into that category, Mr Speaker. No, Paul Quinn can't handle it, Mr Speaker. Paul Quinn can't handle it at all. I agree with Tauhanare. Mr Speaker, there's really a four-pronged attack on job security in this. There's an attempt to weaken the process. There's an attempt to extend the range of reasons for dismissal. They restrict the right of appeal.
Point of order. The Honourable Stevie Chadwick.
I can't even hear, and I'm sitting directly opposite the member who's not in his own chair interjecting.
Well, I would have some sympathy with a point of order, but I'd have to say there's been some provocation from both sides, on both sides of the matter. The Honourable Trevor Mallard.
Mr Speaker, these changes are unfair, they're unbalanced, they're unnecessary and they are ideologically driven rather than being driven by people with any real knowledge of how wage and salary earners live in New Zealand these days. They attack job security, they weaken the processes, they extend the range of reasons for dismissal, they restrict the right to appeal and they restrict the right to reinstatement. I mean, what an outrageous government that tips away the balance when someone wins their case. The government says the balance shouldn't be towards them getting their job back again. That is the sort of approach from the National Party that we're seeing here today. It is part of their attempt to drive down wages, and it proves that before the election there were lies told about the wish to close the gap with Australia. There were lies told before the election about the wish to close the gap, because what we have seen under legislation, members should all look in a mirror. Members should all look in a mirror occasionally. Mr Speaker, what this does is make a lie of the commitment to close the wage gap with Australia. What it does is it allows people to be sacked without a reason. And that's just not fair. New Zealanders don't like that. New Zealanders are for fairness. New Zealanders think, New Zealanders accept trials, they accept probationary periods, but what they say is that if you're not going to be employed at the end of that, if you're on a trial, if you're on probation, you should have a reason. It's pretty fair, pretty reasonable. No reasonable person would disagree with that. No one's saying you have to keep the job, but if you're not keeping the job, then a reason should be given. Mr Speaker, the Prime Minister made a promise to the CTU as to processes around the access provisions. He said it wasn't a priority for the government. Business New Zealand said it was not a priority for them, and the Prime Minister said that he would discuss the matter again before he made any public announcements on it, and Sir, he has been shown not to tell the truth on that issue now. And Mr Speaker, I think it's one of the things that we used to see quite a lot of around here, but in recent years, and I want to include in the latter period of the Honourable Jim Bolger, there was a high emphasis being put on people keeping their word and being honest, and that has been abandoned by the Prime Minister in this legislation. Mr Speaker, on the question of access, I think it's a pretty simple issue, and that is that if a worker has an immediate problem, if there's a grievance issue, subject to things like safety, normal working arrangements, the sort of things that have been there, then they should be allowed to ask someone from their union to visit them on the site in order to try and sort the issue out. It's not an unreasonable thing. Again, it's a matter of pretty basic fairness that Kiwis believe in, that if there is a problem, if there is an issue in the workplace, then someone from the members' union should be allowed to come in to talk to them about it, and it should be pretty immediate and not put off till the next day or the day after by an employer who may well be attempting to mislead people as to what is actually going on. And even Kate Wilkinson, I want to quote Kate Wilkinson, when she said just over a year ago, there does not appear to be widespread evidence of union representatives exercising their current rights to enter workplaces in an inappropriate way, resulting in disruption for business operations or adversely impacting on the employment relationship between employer and union members. And I agree with Kate Wilkinson. I don't think as Minister of Labour in a year I had a single complaint that came to me about that. I don't know of any that came to the department. Certainly none were reported to me of that. I think what we're trying to do here is to solve a problem that doesn't exist, but in doing so take away what is a fair entitlement for workers to get on the phone and say to their union representative, can you come along and try and help sort out this problem that I've got? That's not an unreasonable thing to do, and I think that most Kiwis think that is fair enough. The 90-day area is one which I've referred to before, and it is relatively simple, and it does go to whether someone is entitled to a reason when they're getting the sack. Not even saying a good reason, but a reason, whether they're entitled to a reason or not. And I might say that we're seeing some parallels on that particular issue in these buildings over the last couple of days. Very well set out by Heather Roy. By Heather Roy when she said, and I quote, talking about someone who was the leader of her party, as previously arranged, Rodney Hyde came to my office to view the defence document. He took it away from me and turned to leave. He explained that he couldn't take it away, but could read it in my office, and explained again the security classification that he holds. He refused to leave it here. He turned to leave my office. Short of standing up in the doorway or coming from behind my desk and taking the document from him, I couldn't stop him from taking it from the office. So what you have here is a very clear case of someone who is effectively an employer. He's a leader of a party, pretty close to being an employer for these purposes. Certainly enough to get Heather Roy sacked. She could not intervene. She could not intervene in that way. And what we have here is one of her former fellow ministers saying that she thinks this is all right, and she thinks it is something that can be extended to other people. I say to this House, Mr. Speaker, what this is designed to do is to say to ordinary wage and salary earners, we want you to have fewer rights. It says to wage and salary earners, we don't want your wages to go up. It says to wage and salary earners, we are happy with the gap opening up with Australia. We don't want your union to be able to come in when you call them, and we don't want you to be given a reason when you get the sack. This is, Mr Speaker, the sort of legislation that I would have expected from a 1960s national government. I think actually